HOA secretly rented my property for events. They didn't expect federal charges. The house sat at the edge of the development like a quiet afterthought, separated from the manicured symmetry of the neighborhood by a narrow strip of trees and a private access road. It was a large colonial-style property with a wraparound porch, tall white columns, and a wide-open lawn that sloped gently toward the water beyond. For years, it had been known simply as the Harrington House, a privately owned residence that predated the HOA by decades. What most people in the neighborhood didn't realize was that the house was not governed by the HOA. It had been grandfathered out when the association formed, protected by easements, zoning agreements, and property clauses that had been reviewed and reaffirmed multiple times. The homeowner, Daniel Harrington, had inherited it from his father, who had fought tirelessly to ensure the land remained independent. Daniel was a quiet man in his early 40s, a financial compliance consultant who spent most of his time traveling for work. When he was home, he valued privacy above all else. He kept to himself, maintained his property meticulously, and avoided HOA meetings entirely. He had no reason to attend them, or so he thought. The first sign something was wrong came on a Thursday evening in late spring. Daniel returned home from a week-long business trip to find tire tracks pressed deep into his lawn. Not just one set, but several, overlapping and clearly recent. He stood at the edge of the driveway, suitcase still in hand, staring at the damage in disbelief. At first, he assumed it was an accident, perhaps a delivery truck that had turned around too sharply. But as he walked closer, he noticed flattened grass leading toward the side of the house. Chairs had been moved. The porch furniture was rearranged. A faint smell of spilled wine lingered in the air. Inside, the house was intact. Nothing was stolen. Nothing was broken. But it didn't feel right. The floors had been mopped hastily. Trash bags sat in the outdoor bins, overflowing with disposable plates, plastic cups, and catering containers Daniel didn't recognize. He reviewed his security system logs. The cameras had been disabled. Not cut, disabled with a passcode. That was when unease turned into something sharper. Daniel contacted the security company immediately. They confirmed that the system had been temporarily overridden using an administrative access code tied to a property management account. That made no sense. Daniel had never authorized any third party to manage his home. The next morning, he walked the perimeter of his land. Along the access road, he noticed fresh gravel and chalk markings near the entrance gate. Someone had used his property deliberately, not accidentally. By Sunday, the answer came to him uninvited. Daniel was preparing breakfast when he heard music drifting through the trees. Laughter followed. Then voices. Dozens of them. He stepped onto the porch and froze. Cars lined his access road. Catering vans were parked near the lawn. A tent had been erected near the water. People in semi-formal attire were milling around, holding drinks, chatting as if they belonged there. A banner hung between two trees. Lakeside Community Spring Gala. Daniel stood motionless, disbelief giving way to anger. He walked straight down the porch steps and approached a woman wearing an HOA badge, clipboard in hand. She smiled politely. "Sir, guests are restricted to event areas. Residents should." "This is my house," Daniel said calmly. Her smile faltered. "I'm sorry. You're standing on my private property." She glanced at her clipboard, confused. This venue was reserved through the HOA. All permissions were approved. Daniel didn't raise his voice. He didn't need to. "You have no permission, no lease, no right to be here." The woman stepped back, clearly unsettled. "I need to contact the board." Within minutes, 3 HOA board members arrived, including the president, Martin Keller. Keller was a tall man with silver hair, known for his authoritative tone and polished demeanor. He approached Daniel with practiced confidence. "Daniel," Keller said, extending a hand, "there seems to be a misunderstanding." Daniel didn't shake it. "Then clear my property immediately." Keller sighed. "The HOA has an agreement." "With whom?" "With the property management entity associated with this land." "There is no such entity," Daniel replied. Keller's expression hardened. We've hosted events here before. Daniel's eyes narrowed. You've what? Keller gestured to the guests. The location is ideal. Lakeside. Private. We've rented it out for fundraisers and private functions. It benefits the community. Daniel stared at him. You've been renting my house without my consent. Keller lowered his voice. Daniel, there's no need to escalate this. The HOA has handled all logistics. Cleaning crews, insurance riders. You've never complained before. That's because I didn't know, Daniel said. Keller crossed his arms. The funds go back into the neighborhood. Get everyone off my land, Daniel said flatly. The event was shut down within the hour, but the damage was done. That night, Daniel sat at his dining table surrounded by documents pulled from county records, old property agreements, and HOA bylaws. Nothing granted the association authority over his land. Nothing even came close. Yet someone had created contracts. Someone had collected payments. Someone had disabled his security system. Over the next 2 weeks, Daniel uncovered the truth piece by piece. The HOA had quietly listed his property as a community event venue in private marketing materials. They charged thousands per event, funneling payments through a shell account labeled as Facilities Enhancement. Contracts bore forged signatures. Insurance documents referenced a non-existent leasing company. The scale was staggering. More than a dozen events over 3 years. Weddings, corporate retreats, fundraisers, tens of thousands of dollars collected. None of it disclosed in HOA financial statements. Daniel contacted an attorney, then another, and then a forensic accountant. What began as civil trespass quickly crossed into criminal territory. Forgery, fraud, wire transfers, tax evasion. When Daniel formally requested HOA financial records under state law, the board delayed, then denied, then panicked. Emails were deleted. Accounts were shuffled. Keller resigned abruptly for personal reasons. It didn't matter. The paper trail was already preserved. Daniel's accountant flagged interstate wire payments and misreported income. His attorney flagged federal jurisdiction. By the time federal investigators contacted the HOA, the neighborhood was buzzing with rumors. Residents were stunned to learn their association had been secretly renting private property. They were even more shocked to learn where the money went. As subpoenas were issued and interviews conducted, the full picture emerged. This was no misunderstanding. It was a deliberate operation, and it was about to collapse. Federal agents arrived quietly at first. Unmarked vehicles parked along the curb. Men and women in plain clothes entered the HOA office carrying briefcases and laptops. There were no flashing lights, no dramatic arrests, just methodical precision. By then, the board was unraveling from the inside. Emails surfaced showing that the HOA president, Martin Keller, had personally approved every rental. He had coordinated with an event planner who believed the HOA owned the property outright. Contracts were routed through a shell LLC registered out of state. Funds were split between multiple accounts, some labeled as community improvements, others flagged simply as miscellaneous. Daniel cooperated fully. He provided access logs, property records, camera data, and documentation dating back decades. His attorneys maintained distance, letting facts speak louder than emotion. The HOA tried to control the narrative. A letter went out to residents claiming administrative errors and miscommunication. It didn't work. When residents demanded transparency, the board refused. That refusal triggered state-level audits. Those audits uncovered unreported income, falsified meeting minutes, and unauthorized expenditures. Then the IRS stepped in. What sealed the case was the misuse of interstate commerce. Payments from event clients had crossed state lines. Contracts were emailed. Funds were wired. That made it federal. Within weeks, charges were filed. Martin Keller was indicted on counts of wire fraud, forgery, conspiracy, and tax evasion. 2 other board members faced accessory charges. The Shell LLC was dissolved by court order. HOA accounts were frozen pending restitution. The neighborhood changed overnight. Residents who had once trusted the board now avoided the office entirely. Meetings were tense, emotional affairs filled with anger and disbelief. Homeowners demanded to know how their dues had been handled, how long the deception had lasted, and whether they were liable. Daniel attended one meeting. He didn't speak much. He didn't need to. When Keller was escorted into court weeks later, cameras finally appeared. Headlines followed. HOA officials charged in secret property rental scheme. Private home used for HOA events without owner's consent. Federal fraud case shakes suburban community. The case moved quickly. Evidence was overwhelming. Keller accepted a plea deal. He was sentenced to prison and ordered to pay restitution. The other board members received probation and permanent bans from HOA leadership roles. The HOA itself was placed under external management. New bylaws were drafted. Financial oversight was mandated. Annual audits became law. As for Daniel, he restored his property. New security systems were installed. Legal notices were posted. A gate was reinforced. But more than that, his case changed the neighborhood. Residents became informed. Questioning replaced blind trust. Transparency became expectation, not suggestion. Daniel never sought revenge. He sought accountability. And in the end, accountability reshaped everything. The house by the lake returned to silence. And the HOA never crossed that line again.